I welcome you all to the SADC Parliamentary Consultation on the Model Law on Prison Oversight. This morning, the overarching discussion is consultation on supporting the needs of refugees and migrants through improved prison oversight. Consultations to ensure the model law reflects the compounded vulnerabilities of refugees, migrants, and that prison oversight mechanisms are aware of how to respond and document these vulnerabilities. Mr. Franz Celestin would have been our keynote speaker this morning. He is not logged in. So I would please call upon our well-abled colleague, Anneke, in the meantime, to give us what the model law entails while we wait for Mr. Franz. Anneke, please take the floor.
Good morning, Ms. Mulapo, and good morning, esteemed colleagues. It's good to see you here again today. Many of you have joined the other consultations, and we thank you for persevering as we try and figure out what the best format and content should be for the model law. So because I can see many people are repeat attendees at our consultations, there's a high recidivism rate for people attending our consultations, which is great. So I want to not go into detail about the model law, but just to say a few things as it relates to refugees, migrants, and stateless persons. As again, the key issue is one of considering the needs of vulnerable groups and upholding human rights and dignity irrespective of people's citizenship within the country. And another thing that is quite critical is that we do know how many people are being detained within prisons for immigration-related or administrative-related offenses. This is important because it both leads to overcrowding within our prisons, which is something that needs to be addressed, but it's also an indicator of increased harassment sometimes of persons who find themselves within the borders of a country when they are not citizens. So there's many issues there that ought to be looked at. And I think what's especially hard is when people are being detained in prisons for immigration-related offenses, their contact with the outside world can be quite limited, and there might be huge barriers in relation to legal aid and in relation to language that ought to be taken into consideration. So I'm not going to deal with everything, but I think, again, there's important issues around who can do oversight of prisons as it relates to refugees, migrants, and stateless persons. And what would be important is for the designation of official visitors within prison legislation to recognize that there might be other bodies that ought to have access. Often it's consular services are provided, but one do also think, for example, like international organizations like the ICRC or the IOM or any other sort of organization dealing with foreign nationals, refugees, migrants, for them to be able to have access so that they can provide persons with the support that they need to either regularize their stay within the country or to assist them should they be returned to their own countries. The Judges themselves do visit prisons, and it's important that they are aware of when people are being detained illegally within prisons, because prisons ought not to be a place where people are being detained purely because they are foreign nationals. And where judges come across such situations, they ought to ask people, or they ought to inquire about the legal basis on which people are being detained within a facility. And what we often find is that sometimes when there are roundups of immigrants or migrants within a country, children are also caught within that, and everyone are then transported to prisons without due process and without even properly ascertaining their migration status. So it's important for justices to provide oversight over the legality of people's detention. I won't go into great detail on that. And then the same applies to national human rights institutions. And these are either human rights commissions or ombuds, and they exist in all countries. And they ought to be able to access all places of detention, including places where migrants are being held for migration-related reasons, and they ought to interrogate both the conditions of such detention and the legality of such detention. And then I'll skip a bit, but if we look specifically at foreign nationals or stateless persons, I think there's a few things that we can perhaps consider for a model law. The one would be that when oversight bodies goes to any correctional center, they ought to ascertain the legal framework under which people are being detained. That can be either immigration law, refugee law, or the criminal justice system itself. And in each of those cases, there are legal requirements that ought to have been met to justify such detention. When people are deprived of their liberty and require interpretation, the oversight mechanisms should ideally not use interpreters employed by the correctional center itself. The reason for that is that they might not then get the information they need from persons who are detained, where they have specific complaints against the staff of the correctional center. And it would also place them at increased risk of reprisals if they do complain. What would be important is for oversight bodies to regularly check immigration-related detention to see whether it is lawful, and to ensure that such detention is used as a last resort only. And this is very, very important because it so frequently happens worldwide where people are being detained and imprisoned for reasons that are unjustifiable and simply on the basis of not having the required documents at the time when they are confronted by the police or an other law enforcement body. When people, refugees, asylum seekers do enter a facility, they ought to be given contact with the UN High Commission for Refugees or any other organization working on immigration detention. And it's important that all oversight bodies, when they find foreign nationals within a detention facility, that they ascertain whether or not people are accessing the same level of services as other people within the facility, and to ensure that there is no discrimination based on a person's nationality. It's also important to see whether foreign nationals are able to access and contact their consular representative, and whether their right to an interpreter and legal services is adhered to. What we want to ensure is that the model law provides specifically that all national human rights institutions and independent correctional service oversight bodies and civil society organizations have the authority to inspect detention facilities where foreign nationals or stateless persons are held, and to ensure that such oversight bodies have access to the necessary detainees, the documents, and the facilities, and to be able to publicly report on their findings. There are, and as I mentioned, it's important to look at issues of interpreters, but it's also important for oversight mechanisms to have expertise around migration and around child protection. They must also understand the particular vulnerabilities of children and women who are foreign nationals, and where people are likely to be deported, there should be a safe transfer, repatriation, or resettlement of foreign nationals following that is consistent with international human rights law. Yes, so that's basically sort of the sum of some of the issues that's just important to look at. So the key issues are around legal aid that's available without discrimination, especially allowing people to participate in immigration-related processes or judicial processes, that people are informed of the possibility of voluntary repatriation or the regularization of their status, depending on the law in the country, and that people are able to inform in a language that they understand of what their rights are and what their remedies are. And the important thing is that stateless persons should not be treated as illegal migrants, and their status should be determined in accordance with international standards. So these are some of the issues. I know there's a great many more that people might want to raise, and there are experts in the call on the webinar who specifically deal with these issues and would be able to assist us in this regard. So I'll stop the presentation and then see if there is are any comments.
Thank you, Aneke. I think there's a lot to learn on this topic on migrants, refugees, and stateless persons. Stateless persons should not be treated as criminals. I think there should be a multi-stakeholder training on this, especially starting from the police. When one is caught on doing their business, one has no papers, one automatically is treated as a criminal. They don't speak their language. There is no consular of their country in that country. I think hurdles of migrants are much harder than the rest of us. So I think this model law really is going to be an eye-opener to a lot of us. I think France is still not in the room with us. So for now, I think we can open it up for a discussion with the members in the room. We can write in the comments, or we can react with raising our hands and saying which organization we come from, and we say our names, and then we can have a fruitful discussion. We are looking for country experiences so we can enrich the discussion and we can enrich the model law. We are also looking for experiences of our own, and so that Aneke can really have an enriched experience. Sinetemba, I see your hand up. Please, you can have the floor.
Good morning. Am I audible?
You're audible.
Okay, I hope everyone is okay. My name is Netemba Ngube from Center for Child Law. I'm a candidate attorney there. So I just wanted to add just a 2 cent comment on what was shared. I think another thing that should be incorporated through this module is mechanism to facilitate safe repatriation for especially for refugees, in which we try to make it consistent with the international human rights law and the principle of non-refoulement. And then this is regarding after they've been released from detainment. And I joined the meeting a bit late because I was having network problems. I don't know if you guys have touched on children who are born to detained foreigners or stateless mothers in terms of it, because the organization that I work with is just basically child law. What we've seen through the SADC model is that when it comes to birth registration, that is where they usually suffer, even when the children have been released. Because if we're being honest, chances of them going back to their countries are really slim. So having the children's birth registered immediately, in which the detention facility will not be recorded as the place of birth. And then this will also allow the children in future to easily sort of have access to obtaining citizenship. That's all.
Thank you so much, Sinetemba. We had not discussed that actually. Anike?
Thank you, Sinetemba. I think this is extremely important. And I think figuring out the mechanism through which one would then ensure that these children needs are being looked for and that their status is that they are being registered is very critical, and we will certainly include that.
There was another hand that was raised. There was a hand that was raised with Sinetemba's hand.
I've just raised it.
You have a bit of an echo coming.
Device.
I think you have to, you're open on two
devices.
devices, yes. You can go ahead, Tiny.
Good morning.
Good morning.
Yeah, sorry about that. I'm not very sure whether I am on the topic, because first of all, I had my hand raised because there was this echo. I didn't understand that it was coming from me. But anyway, since I'm on the floor, did I hear you saying, because I couldn't hear properly, but did you say that we could share our experiences or something like that? Yes.
Yes, yes.
Yeah. Oh, I'm from Botswana and I work for an NGO that works in the refugee settlement. And I must applaud the new government that they have, we have been struggling with the detention of migrants, especially those seeking asylum. We've been struggling for years and years in the previous administration. People would stay in the camp for even up to 5 years or so. But now with the new administration, a lot of people were released. They're back in the settlement. And because the reason why I understand why they were kept there was because they were rejected as asylum seekers. So they were left to stay there in the Center for Illegal Immigrants. But now I think 400 and something were released in June. And it doesn't mean that all of them have been given asylum, but at least they are not detained. So I understand that there are arrangements now to take them home. So this is a very positive step of the new government. Thank you.
Thank you so much. Taking care of asylum seekers. We have message here on the chat box. Morning, everyone. I'm from Botswana. My name is Mary Ann Mbaeva. I will say my comments later after the discussions. Thank you, Mary Ann. Any more hands? Country experiences, technical expertise, or experiences? We are talking on the vulnerabilities of refugees, migrants, and displaced persons.
If I can ask, Ms. Malapo, I see a colleague from Malawi, Apatsa Mhango, who's on the call and has specific experiences around the detention of migrants in Malawi, in prisons, and the need for there to be oversight to be able to assist in their release. And there has been some good judgments from Malawi as well. So I wonder if Apatsa might want to speak to that.
Thank you. Experiences from Malawi. There's a message on the chat box from Apatsa Mhango. The SADC model law on prison oversight should explicitly integrate measures to prevent and monitor human trafficking within detention and deportation processes. Given the growing link between irregular migration, detention, and trafficking across the region, it is essential that all deportations are lawful, transparent, and properly documented, with the presence of neutral third parties such as the national human rights institutions, the Malawi Human Rights Commission, IOM, or UNHCR to ensure adherence to human rights standards. Civil society organizations should also be formally included in monitoring deportation and transfer exercises to safeguard against abuse and protection rights and dignity of migrants and refugees. Member states should further strengthen anti-trafficking oversight mechanisms within prisons and detention centers, recognizing that trafficking can also occur through the misuse of official authority, as illustrated by a recent case in Malawi. Sorry, I cannot talk, but I can drop a comment on what Anneke just said. A moment on the cases. And there's also a link. Here's our report on policing and xenophobic violence in South Africa. We have one also from Sinetemba Nkube. Detainees who do not understand the official language should be provided with interpreters during all legal, administrative, and disciplinary proceedings. Legal aid should be made available without discrimination, ensuring meaningful participation in judicial or immigration-related processes. Detained migrants shall be informed of possibility of voluntary repatriation or regularization of their status. I think that one is not complete. And there's one from Louise Edwards. We have also advocating for strengthened oversight of policing of migration in South Africa, which is implemented properly, could reduce arbitrary deprivation of liberty, and has some lessons in terms of oversight in a prison context. There's also a link. There's a continuation of Sinetemba's message. Women who are pregnant, breastfeeding, or primary caregivers shall not be detained except as a last resort and for the shortest period necessary. Alternatives such as open or halfway houses and community-based rehabilitation shall be prioritized, consistent with Bangkok rules and Article 30 of ACRWC. Victims of human trafficking, torture, or gender-based violence shall receive trauma-sensitive care and psychosocial support. I think that's the last of our chat box. Do you have any more hands?
So I think, Ms. Manapa, I just want to ask everyone, I know there's a lot of experts on this call who are know a lot more than on issues relating to refugees and migrants than what I do. And I think this is the opportunity for people to just raise their hands and volunteer comments on what they feel are important issues that we need to consider and that we need to include within the model law. So I think the more the merrier in terms of if people want to raise their hands and also if they have said stuff in the chat box but they want to develop on it further or speak about it further, yes, I would encourage them to do that.
Thank you, Anneke. We have a hand from Louise Edwards. You have the floor, Louise.
Thank you very much, and thank you for the invitation to attend the webinar. So I just wanted to raise one issue, and I'm not sure how best to capture it within a model law, but we've been doing a lot of work, as I put in the chat box, at the front end of the justice system. So looking at issues around policing and enforcement of both criminal law and immigration enforcement in South Africa in particular. And one thing that has become very clear in that work is that you can have extremely good legal frameworks, great regulatory kind of control in terms of both the discretionary use of power as well as the kind of procedural safeguards that should be in place to protect migrants, refugees, and non-nationals. But what overlays it is broader perceptions of migrants, refugees, and non-nationals within both the institutions, so whether it's police or prisons, in addition to sort of broader societal engagement. And what we found with the work specifically with the police was that the research showed there was sort of quite deeply ingrained xenophobic attitudes by the police as an institution and individual officers towards non-South Africans. And it plays out in terms of the arbitrary way in which the regulatory and legal framework is upheld or not. But in those personal interactions between the officials and the people deprived of their liberty. And so part of that process was around like a heart and mind change by the police as an institution in terms of pushing back against what are very clear kind of xenophobic overtures. What we also looked at was the role of oversight in this context, and oversight being aware of xenophobia and othering of migrants, non-nationals, and stateless persons in terms of identifying and responding to the risks inherent in the context of deprivation of liberty. So I'm not sure how to include it. Some of the practical stuff that we have done is around training, and not training in terms of this is what your standard operating procedure says and you must therefore follow it. But it was using like an adult education methodology to try and break some of the biases around othering people who are non-nationals. So there is a very strong oversight role there, I think. So in terms of prison oversight, identifying xenophobia as a key risk factor for ill treatment, because we can have the most beautiful regulations and standing orders around protection, but those individual officers, the extent to which they are both supported and understanding of why they're in place, as well as then the overt discriminatory treatment. So I think we need to address that somehow. Thanks for letting me have the floor.
Thank you, Louise, for your submission. Xenophobia. Any more submissions, colleagues?
Can I pop in there, Ms. Malapo?
Yes, please.
Let me start the debate now that Louise is online. This issue of xenophobia is not just in relation to South Africa. We know that it's global, and we know that it's escalating. And if we look at the US as an example, it's very clear how within a short period of time, one can suddenly have all these legal frameworks and procedural safeguards thrown out of the window, basically. And like Louise said, a lot of that is about societal sentiment allowing the law enforcement bodies to do that. And if we look at oversight, we can then assume that once people are detained in prison, where they are detained as a result of government measures that and government policies around mass arrests, then it's much harder for prison facilities to push back against it and say that we cannot actually detain more people within a facility. And it's important then that oversight mechanisms are able to step in and actually say that some of these detentions are illegal. And I think this is really where the critical issues come in about independent oversight bodies actually having the funding to be able to step in to oppose government policies when those government policies lead to mass arrests and increased overcrowding of detention facilities and violation of rights and those sort of things. So I almost wonder if, like, we mustn't just look at the situation now, we must be forward looking and think about what if we end up being like the US, where we randomly detain people in mass and ignore their rights and deport them before they've even seen a court or a lawyer. That's the one issue. The other thing is, already now we have countries in our region accepting deportees from the US.
Yeah.
And it is virtually impossible for oversight bodies to access and interview those deportees. And I know that from personal experience, having tried. And I think that then raises important other questions about, firstly, how we define official visitors, for them to include civil society, and for them to not only relate to government institutions when government institutions might feel compromised in terms of certain policy decisions. And then the other thing, the point of the issue around training itself, that we specifically include xenophobia and immigration, international law relating to migrants within the model law as a requirement of training, so that prison officials aren't just aware of the normal laws relating to prisons, but they ought to be aware of the conventions and human rights standards relating to migrants. And I think that's something that's lacking at the moment that we haven't yet put in the model law. And I want to thank Louise for highlighting sort of some of those things. I think there's also around mandatory reporting, there's something there about them. The prison facility might know how many people are in the prison who are there under for migration related reasons, but us as the public do not know. So we might not then actually be able to highlight and advocate for issues because we actually don't have the knowledge of. I mean, if suddenly the public was aware that at the moment there's 20 babies being detained with their mothers who are migrants, that would be something that's quite important, but the public would never know that. So how do we create a mechanism within the model law where mandatory reporting becomes public reporting? And what would people suggest around how we actually do that?
I think that is where the issue of data has always come up in all the sessions. Today it has not been raised, but in all the sessions, the issue of data and data collection and the integrity of data has always come up, that every day in all the sessions, like, there has to be disaggregated data collection. There's a chat box from Marianne. I agree, Anneke, data is very crucial. One is from Louise. I think that's a great idea, Anneke. Context is key in terms of officials understanding why the procedural safeguards exist and why special measures are in place to protect the rights of migrants, refugees, and stateless persons in detention context. I think mandatory reporting is very important here. Data should 100% be disaggregated in terms of nationality, in addition to other categories that are usually covered, including gender, age, etc. Yes. Data. Is there anything else, colleagues? There's another one in the chat box from Hwango. It says regular multi-stakeholder gatherings could also help in terms of sharing data and figures.
Can I ask Ms. Mulapo just to get some views from people on a related issue around healthcare services and referral to healthcare services and how the interaction between health departments and prisons as it relates to migrants who might often fall through the system in a sense and might not be able to access the medication that they ought to be accessing. I don't know if people perhaps have particular experiences that they think might be useful for us to be aware of when we look at the model law.
Healthcare services of people already in detention. Access of health services. Any submissions there? How easy is it? Any experiences, any country experiences, colleagues? Anything that could go into the model law?
My hand is up.
Oh, I thought that was a clap, Tiny. You may go ahead.
Oh, sorry. Yeah, okay. I think in Botswana, really the detainees are more or less treated like prisoners. So they do have access to healthcare. If they have issues, they are taken to the health facilities. Yeah, and like even children, when they are born, the mother will go to the hospital and the child will be born there and they'll be issued with birth certificates. So yeah, thank you.
If I may ask, the birth certificate is this child is a Botswana citizen?
No,
Okay.
it is, yeah.
Any more submissions?
I think if I may, Chair,
Yes, please.
it's not really about it's not about health, but it's about education.
All right.
The issue is that when people are detained and they have children in Botswana, the children unfortunately do not have access to education. That's why we are very grateful that the new government has taken a stand to release the detainees, especially those who have children. Yeah.
Okay. Thank
Can I
you.
come in?
Thank you, Senator Mba.
So in South Africa, usually I don't have much of knowledge on the criminal aspects and the Department of Health. However, I've seen in hospitals whereby you see prisoners in shackles. For example, I think it's safe to assume if they are having any health concerns, they are taken to hospital. But right now, from I think earlier this year, we have this Operation Tutula that's going on in which immigrants, refugees are refused basic services such as children who are not documented are not allowed into schools. people who are not documented, including their children, they are not allowed into hospitals or to get access to health care. Before, that wasn't an issue. So I think currently it is safe to assume that already they are detained. Majority of their human rights are infringed, taking into account that as much as we would like to sort of sugar-coated, they are being discriminated in there. And then with this Operation Dudula that's going on, it's safe to assume that they are not getting the necessary health treatment. But when it comes to the school part, we would get like queries from parents who are not documented or have children that aren't documented. Usually that one is very easy because we just quote the law, the reported cases, which say that every child in South Africa, regardless of their citizenship, their citizen status, documentation status, they have a right to education. So usually with that one, we just write a letter to the school telling them that the law says this, admit the child into school, and then they're admitted. But on the health part, it's a bit tricky because there are people who are doing like the actual, I would like to say, groundwork, who go to hospitals, clinics every day in the morning, ensuring that foreigners, by foreigners, I'm including everyone, refugees, immigrants, illegal immigrants, they are not allowed to get inside the hospital.
Thank you for the submission, Sinatamba. We have one in the chat box from Louise. It says, has the issue of alternatives to detention in my immigration enforcement context been raised? Most countries have alternatives available, but there is weak application. Detention becomes default approach in migration management. From an oversight perspective, it would be very important for oversight bodies to understand what alternatives are available and whether the decision to detain a migrant is legal, appropriate, and necessary. This might be an issue of training for oversight officials, knowing what alternatives are available and questioning whether the alternatives were explored before detention was ordered. Alternatives to detention. We have one more from Abata. In Malawi, prisons do have clinics and detainees generally have access to healthcare. However, these clinics are sometimes understocked and lack essential medicines. I believe the Department of Health should be actively involved in these discussions, and this should be captured in the model law to ensure that when referrals are made, particularly in cases where medications need to be administered, I lost my particularly in cases where medication need to be administered to refugees, they are adequately supported. From Apata in Malawi.
I think if I can come in, Ms. Malapa, I've documented all the comments that were in the chat box and that were raised. So we have particular issues around training, around data, around dealing with xenophobia, the multi-stakeholder sort of engagements, health services, access to education, and alternatives to detention, and as that links with the international legal framework. So I think this is quite a bit for us to incorporate within the model law itself. I do have to note that at the moment, the model law deals only with prisons.
Right.
So this would apply to when people are detained within the prison setting. And I just want to flag that because I want to ask people the extent to which there is oversight of other immigration detention facilities and whether or not there is a need for coordination or collaboration between prison oversight facilities and other immigration detention facilities, if that makes sense. So I know, for example, in South Africa, you have Lindela, which is where people are being detained. In other places, there might be other immigration detention facilities, and these would fall under the Homeland Security type departments and not necessarily under the same departments, but we do want to know the extent to which these facilities are being visited, for example, by national human rights institutions, because that could then be something that one can think about, including in the model law, to just encourage that national human rights institutions and official visitors have broad-based access to all places of detention.
Right. I see a hand from Doreen. You can take the floor.
Thank you. Like Annika said, in South Africa, there's Lindela, right, which is the immigration detention facility. But we also do still have people being held in either police holding, police detention, and maybe even not maybe, and also prisons, whilst they're waiting to be sent to Lindela to be processed for deportations. But so with regards to oversight of Lindela, if I'm not mistaken, maybe Louise can also jump in here. This oversight is under the jurisdiction of, the South African Human Rights Commission, and definitely collaboration is necessary, or the encouragement of collaboration through the model law is necessary. In theory, this is something that is possible here, right? But it's also recently through the the designation of the Human Rights Commission as the national preventative mechanism, kind of then been reinforced by by the designation of the SHRC as the NPM to enable, this kind of collaboration or alignment between alignment of oversight in detention immigration detention facilities that can be worked into the model law. But I think something that speaks to that is really important in the drafting or development of the model law, to ensure that this coordination is sustained, it's sustainable, it's sustained, and it happens constantly, right? And not just occasionally, and that there's also adequate resources allocated for that to happen. Yes.
Thank you. Thank you, Doreen, for the submission. We have one message in the chat box from Louise. It reads, you're right, Doreen, and there is a gulf between mandate and actual oversight. We did a paper on it a few years ago, which was before the national preventative mechanisms, but challenges still remain, and there's a link, I think it's to the paper. Thank you so much, Louise, from Louise. Oh, one last message from Abata. It says in Malawi, there are shelters at border posts that temporarily hold refugees. However, these facilities are not consistently monitored or inspected. This lack of oversight has contributed to human trafficking, as some officials exploit the situation by facilitating the illegal movement of refugees out of the country. Coordination with civil society organization is often absent, meaning that many of these incidents are only discovered after they have occurred. Thank you, Apata. It's a submission from Malawi. Thank you very much, colleagues, for your submissions and taking time out of your busy schedules. I think if there are no more hands, we can end our sessions here. And there's still time to make your submissions to the SADC Parliamentary Forum. Let me share our email address. You can share your technical experiences, your country experiences, best practices to enrich the process and inform our drafter Aneke at presence@sadcpf.org. Thank you for being with us today. You have enriched our model law processes. I think we can end our session here. Thank you very much, ladies and gentlemen.